Hello, hi, and welcome. So, today we will be going to the third chapter in Module 2, that is General Clauses Act 1897. So, this General Clauses Act gives some definitions, and these definitions will be applicable to all the central government enactments that are made in the parliament. Whatever the enactments that are made in the parliament and regulations made thereof by the central government through parliament will commonly applicable all the definitions which are given in General Clauses Act 1897. So there are very few important definitions that are given in our syllabus. So, and apart from the definitions, it do contains certain general rules of construction. So how interpretation and how a particular concept or how a particular definition will be constructed will be given in the general rules of construction, and the powers of functionaries, various functionaries and their powers are also been given here, and a provision as to orders, rules, etc. made under enactments, and some miscellaneous concepts are the total topics that we are going to see. So the General Clauses Act, a brief introduction for you is that it contains definitions, as I told you, of some words, also some general principles of interpretation of the statutes made in the parliament. So this act intends to provide certain general definitions which shall be applicable to all the central acts and regulations. And when it comes to the General Clauses Act is very effective in the absence of clear definition in the specific enactments, and where there is a conflict between the pre-constitutional and post-constitutional laws. So if there is any deficiency of any definition in any of the enactments made by the parliament, in such a case, the definitions that are available in General Clauses Act will facilitate the interpretation of the acts made by the parliament. And apart from that, there are certain pre-constitutional laws and some post-constitutional laws, which mean to say before the 1950, say, and after the 1950. So once the constitution is being enforced in full, and thereafter certain enactments were made by the parliament, and those enactments to that of the pre-constitutional laws, which mean to say the enactments are made by the government in power before the constitution comes into effect. So to resolve the conflicts, the definitions and the content available in the General Clauses Act is very useful. And the General Clauses Act gives a clear suggestion for the conflicting provisions and differentiates the legislation according to the commencement and enforcement to avoid uncertainty. Right. The General Clauses Act has been enacted to shorten language used in the parliamentary legislation. Because, say for example, if there are certain definitions in the General Clauses Act, all these definitions need not be given again in the enactments that are being made after the Constitution came into force. Because whenever a person is studying any enactment, first of all, he should study the General Clauses Act and should make himself or herself familiar with the definitions given there. And thereafter, he should go to study the enactment made by the parliament, so that his knowledge of that particular enactment is considered to be complete and comprehensive. So that is the reason this General Clauses Act should be studied by any person who is uh, going to be a part of implementation of any statute made by the parliament. You being the chartered accountancy students, once you come into the professions, you will be instrumental in rolling out the enactments made by the government with respect to the tax laws, or with respect to the company administration or something else. So when you are advising the clients on compliance with respect to the enactments made by the parliament, what is expected of you is that a comprehensive knowledge, a complete knowledge of the enactments is required. To have a complete knowledge, a student has to append his knowledge of the General Clauses Act to the any bare act that is being dealt with to implement. So now we will come to the first topic possible for your examinations. The topic is what is the object, purpose, and importance of the General Clauses Act, which gives enough introduction with regard to this. Right, let us see. The objects of the act are several. There are many objects are there behind making the General Clauses Act. The first one is to shorten the language of central acts. The first one is to shorten the language of central act. So the first object will make the central enactments. Here central acts means the acts made by the Indian Parliament. By having General Clauses Act, the content available in the General Clauses Act with regard to various definitions and with various rules of construction of the statutes need not be repeated, need not again required to be stated in the each and every act, so that the language of these central acts will get shortened. The second objective is to provide for uniformity of expression in central acts. So if you study the bare acts of the central government, I mean to say the Indian Parliament, you will identify the uniformity of structure. So, to start with any bare act, if you deeply understand, uh, if you see it at a minute level, the template, the structure of the expression will be uniform. And the third object is to state explicitly certain convenient rules for the construction and interpretation of statutes. For construction and interpretation of the statutes or the central enactments. The fourth object is to guard against slips and oversights. Here, slips means something missing out, and oversight means something which is not been properly read and identified by importing into every act certain common form clauses which otherwise ought to be inserted in every central act. Right. So these are the four objectives. So to guard against slips and oversights by importing into every act certain common form clauses, this object of the General Clauses Act will be fulfilled. And now we come to the purpose of the General Clauses Act. It is to place in one single statute different provisions as regards interpretation of words, legal principles which would otherwise have to be specified separately in many different acts and regulations. Students, now you understand the purpose. So unless you have a General Clauses Act, it requires to have different acts and regulations are to be given with various interpretation of words and the legal principles. Interpretation of words, the provisions with regard to interpretation of words and the legal provisions are to be given to each and every enactment and regulation made by the parliament. So what will happen? Unnecessarily we do increase the text of the each and every bare act. Instead of that, if you take out the common interpretation of words, if you take out the common legal principles which would otherwise applicable to all the acts and regulations and put them at one place as a single statute in the name of General Clauses Act, it will serve the purpose. It will serve the purpose. So here, to place in one single statute different provisions as regards interpretation of words and legal principles which would otherwise have to be specified separately in many different acts and regulations. This has been stated by the Supreme Court in the case of the Chief Inspector of Mines versus Karamchand Thapar. Right. Now we come to application. Application of General Clauses Act. The Act not defines any territorial extent. Its application is primarily with reference to all central legislation and also to rules and regulations made under Central Act. It is in a sense a part of every Central Act or regulations. If the Central Act is extended to any territory, the General Clauses Act would also deem to be applicable in that territory and would apply in the construction of that Central Act. Right. The central acts to which this act apply are acts of the Indian Parliament, along with the rules and regulations made under the Central Act and acts of Dominion legislature passed between 15th August 1947 and the 26th January 1950, and acts passed before the commencement of the Constitution by the Governor General in Council or the Governor General acting in legislative capacity. The acts the act does not define any territorial extent clause. Right. Unless the context otherwise requires, the GC Act 1897 shall subject to any adaptations and modifications that may be made therein under Article 372 of the Indian Constitution. Apply for interpretation of this Constitution as it applies for the interpretation of an act of the legislature of Dominion of India. Right. This is about the application. So we will have a look at preamble. We will have a look at a preamble. Every act has a preamble. Preamble means foreword. Preamble means a foreword. A preamble describes about what the entire act is going to state about. So every act has a preamble which expresses the scope, object and purpose of the act. It is the main source for understanding the intention of lawmaker behind the act. So it is the preamble which will give you an opportunity to understand the intention of the lawmaker, the intention of a lawmaker behind the act. Whenever there is ambiguity in understanding any provision of the act, preamble is accepted as an aid to construction of the act. In case of an ambiguity, if the interpretation ambiguity happens, so if you refer to the preamble where you will find the scope, object and purpose of the act, it will aid, it will support to construction of the act. The preamble of a statute is a part of the enactment. A preamble of the statute is a part of the law and can legitimately be used for constructing it. However, the preamble does not override the plain provisions of the act, but if the wording of the statute gives rise to doubts as to its proper construction, the preamble can and ought to be referred to in order to arrive at the proper construction. So that was what it is talking about the preamble to the General Clauses Act. Now we will go for some of the important definitions of this act as it is given in section 3. So students, you will get questions with regard to the various definitions that are given here. So any definition can be a question for you for 5 marks. All these definitions can be a question for you for 5 marks. The first definition, see, in the act all the central acts and regulations made after the commencement of this act, unless there is anything repugnant in the subject, these definitions will be applicable for all the uh, bare acts that are made by the Indian Parliament and the regulations made thereunder. So the first and foremost definition that is given under General Clauses Act, that is Act. Act used with reference to an offense. Act here does not mean that General Clauses Act, or see student, if you don't read the definition, if you want to write the answer with a common perception, you are definitely going to give a wrong answer. Here, act means not the act that is given like a negotiable instrument acts or contract act or like that. Act here is differently defined in the General Clauses Act, which is applicable to each and every enactment made by the Parliament. Act used with reference to an offense. Act is used with reference to an offense or a civil wrong shall include a series of acts and words which refer to acts done extended also to illegal omissions. The act required to be done cannot necessarily mean a positive act only, and may also include acts which one is precluded from doing from decree. This definition is based on section 32 and 33 of IPC and applies to civil wrongs as well as crimes. Act includes illegal omissions as well, but it does not include an omissions which is not illegal. In the illustration to section 36 of the IPC, the act by which A causes Z's death, say for example, the act by which A causes Z's death consists of a series of acts, namely the blows given in the beating him, plus a series of illegal omissions, namely wrongfully neglecting or refusing to supply him with food at proper times. Right. This is the definition of act under section 3 subsection 2 of the General Clauses Act. Right. So if at all a question comes right about define the word act under General Clauses Act, then a student is expected to write as it is given in the definitions. We will see and discuss in depth with regard to most important definitions. So this affidavit is the most important definition that will come in your examinations, because affidavit is the word that we commonly use, and affidavit is the word even a common man, not required to be a businessman, which is being used in day-to-day life. So that is the reason a student should have an clear understanding of the word affidavit as it is defined in General Clauses Act. Affidavit shall include affirmation and declaration. See, affirmation and declaration in the case of a person's by law allowed to affirm or declare instead of swearing. So it is this kind of affirmation and a declaration to the courts by a person as a witness will be accepted if it is in the form of affidavit, right? There are two important points derived from the above definition. One is affirmation and a declaration. In case of persons allowed affirming or declaring instead of swearing, the above definition is inclusive in nature. The above definition is inclusive in nature. It states that affidavit shall include affirmation and a declaration. This definition does not define affidavit. However, we can understand this term in general parlance. So we can understand this term in general parlance. Affidavit is a written statement. Affidavit is a written statement confirmed by oath or affirmation for use as evidence, in court or before any authority. Right, this is what the definition that we can understand in general parlance. Students, you understand? So the next definition is central act. It means an act of parliament. Central act mean an act of parliament and shall include an act of the Dominion legislature or of the Indian legislature passed before the commencement of the constitution, and an act made before such commencement of governor generals in council or the governor generals acting in a legislative capacity. Right, this is called a central act. A central act, central government. Now, the definition is about central government. Central government shall, in relation to anything done before the commencement of the constitution, mean the governor general in council. So, central government means before the constitution comes into force, it is the governor general in council in relation to functions entrusted under subsection 1 of section 124 of the Government of India Act 1935 to the government of province or the principal government acting within the scope of the authority given to it under that subsection. And in relation to the administration of chief commissioner's province, the chief commissioners acting within the scope of the authority given to him under subsection 3 of section 94 of the said act, and in relation to anything done or to be done after the commencement of the constitution means the president, and shall include in relation to functions entrusted under clause 1 of article of the constitution to the government of a state, the state government acting with the scope of the authority given to it under the clause in relation to the administration of a part C state before the commencement of the constitution. The commissioner or the lieutenant governor or the government of a neighboring state or authority acting within the scope of the authority given to him or it under Article 239 or 243 of the Constitution, as the case may be. So here, after commencement of the constitution means the president. It is the president who is considered to be the central government, because it is upon the assent given by the president. Only after the consent given by the president to the enactments made in the parliament, it will become enactment and come into force. Until the president gives his stamp and signature on the bills passed by the parliament, it cannot become act. So that is the reason it means the president. It means the president. And Part A states, what are the Part A states? and what are the Part B states, and what are the Part C states that are given here. You have to see. So the 9 Part A states are Assam, Bihar, Bombay, Madhya Pradesh, formerly so and so, and West Bengal. Part B states are given here. There are about 8 Part B states, and there are about 9 Part A states. Even if you write the 9 Part A states, 8 Part B states, that will be sufficient. And there are about the 10 Part C states, and Part D territory was the Andaman Nicobar Islands, are the coming under the Part D. So the next definition is about the commencement. Commencement used with reference to an act or regulation shall mean the day on which the act or regulation comes into force. Coming into force or entry into force refers to the process by which legislation, regulation, treaties, and other legal instruments come to have legal effect or force. The law cannot be said to be in force unless it is brought into operation by legislative enactment or by the exercise of authority by a delegate empowered to bring it into operation. The theory of a statute being in operation in a constitutional sense, though it is not in fact in operation, has no validity. So the next definition is about the document. Document, we keep use this word document in day-to-day life. So how the word document is being defined in the General Clauses Act. Document shall include any matter written, expressed, or described upon any substance by means of letters, figures, or marks, or by more than one of those means, which is intended to be used or which may be used for the purpose or recording that matter. Document shall include any matter written, expressed, or described upon any substitute. It also include by means of letters or figures or more than one of those means, which is intended to be used or which may be used for the purpose of recording that matter. For the purpose of recording that matter is called as a document under section 3 subsection 18. Thus, the term document include any substance upon which any matter is written or expressed by means of letters or figures for recording that matter. Right. So the next definition is about enactment. Enactment shall include the regulation also. The regulations made under that particular act. And any regulation of Bengal, Madras or Bombay court, and shall also include any provision contained in any act, and also include any provision contained in any act in any such regulation as aforesaid stated. It has been held that enactment would include any act made by the Union Parliament or the state legislature. Again, since enactment is defined to include also any provision of an act, Section 6 would apply to a case where not only the entire act is repealed, but also where any provision of the act is repealed. So this also needs to be kept in view while defining what is meant by enactment. Next is the financial year. Financial year mean the year commencing from first day of April. The term year has been defined under section 3 subsection 66 as a year reckoned, means calculated according to the British calendar. Thus, as per the General Clauses Act, year means calendar year. Year means calendar year, which starts from January to December. Difference between a financial year and a calendar year. Financial year starts from first day of April, but calendar year starts from first day of January. That is the only difference between the two. And the next most important definition, this is ninth one, is very important. Good faith. Good faith. A thing shall be deemed to be done in good faith, where it is in fact done honestly, whether it is done negligently or not. The question of good faith under the General Clauses Act is one of fact. It is to determine with reference to circumstances of each case. Thus, anything done with due care and attention which is not mollified is presumed to have been done in good faith. So anything done with due care and attention, which is not mollified, is presumed to have been done in good faith. Example, an authority is not acting honestly where it had a suspicion that there was something wrong and did not make further enquiries. So the term good faith has been defined differently in different enactments. This definition of good faith does not apply to that enactment which contains a special definition of the term good faith given in that particular enactment has to be followed. This definition may be applied only if there is nothing repugnant in subject or context, and if that is so, the definition is not applicable. Right. This is about the good faith. Good faith means you have to remember this is what it says. Anything done with due care and attention which is not mollified is presumed to have been done in good faith. Next is a government. How the government word is defined in General Clauses Act. Government or the government shall include both central and state government. Hence, where the word government is used, it will include central government and state government both. The definition of the object of this definition is to make it clear that the word government, frequently used as a convenient abbreviation, may be construed according to the context in either of the two senses indicated. Government generally denotes three wings. So one is the legislature, which is the Lok Sabha, Rajya Sabha, and the president. The executive here is that at the central level, the executive is the prime minister and his cabinet, and at the state level, it is the chief minister and his cabinet is the executive. And the third is the judiciary. The judiciary, you know that Supreme Court, High Courts, District Courts, and Municipal Courts, and Magistrate Courts, and Metropolitan Magistrate Courts, all these are coming under the judiciary. but in a narrow sense it is used to connote the executive only, meaning to be assigned to that expression therefore depends on the context in which it is used. See, government generally connotes three wings: legislature, executive, and the judiciary. But in narrow sense, it is used to connote the executive only. Government securities. It shall mean securities of central government or any state government, but in any act or regulation made before the commencement of the constitution shall not include the securities of government of any part B state. Immovable property. So this is a very important because it is our financial term that will come very repeatedly. Immovable property shall include land, benefit to arise out of land, and things attached to the earth or permanently fastened to anything attached to the earth. It is an inclusive definition. It is an inclusive definition. It contains four elements. One is land, benefits arising out of the land, things attached to that land, and things permanently fastened to anything attached to the earth is considered as a immovable property. Right? Land benefits arising. See here, immovable property includes land and benefits arising out of land, things attached to the earth, things permanently fastened to anything attached to the earth. Next one is about imprisonment. It shall mean imprisonment of either description as defined in IPC. So as it is defined in the Indian Penal Code, the imprisonment will follow. The IPC, the punishment to which the offenders are liable under that code or imprisonment, which is of two descriptions, namely rigorous, that is the hardcore, and simple. So when an act provides that an offense is punishable with imprisonment, the court may, in its discretion, make the imprisonment rigorous or simple. Indian law. Indian law shall mean any act, ordinance, regulation, rule, order, bylaw, or other instruction which before the commencement of constitution had the force of law in any province of India or part thereafter, or thereafter has the force of law in any part A or part C state or part thereof, but does not include any act of parliament of the UK or any order in council, rule, or other instrument made under such act. So that is called the Indian law. Month. Month shall mean a month reckoned according to the British calendar. The word month occurring in Section 271 of the IT Act 1961 was construed to mean a period of 30 days and not a month as defined in the General Clauses Act. Movable property shall mean property of any description except immovable property. Oath. Oath shall include affirmation and declaration. In the case of persons by law allowed to affirm or declare instead of swearing. Offense shall mean any act or omission made punishable by any law for the time being in force. Official Gazette mean the Gazette of India or the Official Gazette of State. Both of them together is called as Gazette. Person shall include any company or association or body of individuals, whether incorporated or not. Registered means used with reference to a document. Registered, the word is used with reference to a document, shall mean registered in India under the law for the time being in force for the registration of documents. So other definitions like rule, schedule, section, subsection, swear, writing, year, these are all one sentence definitions, and students are expected to have a look at it. So though there may not be a question exclusively for that. Right, with this, I would like to conclude the first session on General Clauses Act. So here that what we discussed is what is the purpose of the act and why it has been come into force, and we have discussed certain definitions which are important by highlighting them in our examination. So I thank you all. Wish you all the best.